Okay, so thank you for being patient enough to connect again. Thank you for being here in Dubrovnik and joining us for the course and later on the seminar and so I will try getting the whole. Such interesting lecture as always, and it's quite a difficult task to talk about limitations of liability after Professor Martinez's knowledge of limitation of liability. So, but I'm going to limit myself in my presentation on limitation of liability for maritime claims in solution in the convention regulating passenger claims. And this convention is actually what Professor Martinez said, not the global limitation of liability, but the special applicable to passenger claims, meaning claims for death of personal injury to passengers and claims for damages to their life. Professor Martinez mentioned, and as you saw in the discussion after the presentation, the justification of the whole concept of limitation of liability is quite in the practice and in theory, and it was questioned especially in respect to those damages in respect of death of personal injury to passengers. And many supported actually unlimited life as a value reflected by institutions, and in respect of those claims, no liability should be allowed. Other persons argued that they should that this concept should remain also in respect of those claims. And solutions actually exist for the passenger claims, and we will see that this special regime contained in the Tuhtan Convention actually intervenes with the LMC Convention and additionally lower the limit of limitation for those claims, and we'll see another. Oops, what I have to do? It's not working.
Here.
So as always, we'll proceed with our presentation. So before we start talking about the limitation of liability, we have to say several words about the forces. The important for this subject is the Athens Convention of 1947, which was brought 1947, and still has certified, and it covers 54% of the emerging fleet, so it's still quite applicable in the around the still member states, not that Poland, but not Colombia. Then there were two protocols to this convention. Here to this 2002 protocol. It was changed in the unit of count, the special towing right, and I'm not going to talk about that a lot at all, actually. And then there was a protocol, quite important issue for the question of limitation of liability, but it never entered into force. And it is quite interesting, actually, this protocol, because it's clear that actually what it said before, there was one circle of states that wanted unlimited liability, and they considered that those limitations thought that limits were too high, so they did not ratify the protocol, and it never entered into force. Now it has only 3 states, and it's not going to enter into force at all, I think. And the most important one for us, the protocol of 2002 to Athens Convention, and the protocol entered into force in April 2014. Now it has 31 member states, of which 18 states. Why so many EU countries are member states? And there is one soft law, one IMO observation and guideline within the EU, this soft law actually became law in the sense that it was incorporated into the regulation, and this regulation is directly applicable in all member states. They're actually also very important for the subject matter because they deal with war risks and limitation of liability in case of and they were brought because the insurance market was unable and unwilling to cover those risks. Why? It was 2000 after the Twins collapse, and the fear of terrorism was quite high, and they were not ready of possible claims. So the IMO reservation was brought, and in respect of those claims, the limits are, as you will see, lower than in other cases. In respect of the protocol, that states are not parties, neither to Protocol of 2002 nor the Convention of 2004. So they are not covered by the applied Convention of 2002 by virtue of the European law, by virtue of regulation 392 of 2000. And how come the European Union decided to regulate this issue? The European Union was very keen on making this Athens Convention. Every country ratifying the Protocol of 2002 had to denounce all previous conventions. So one country can be party only to the and have to denounce all those previous. So we didn't have a problem. Professor Martinez was mentioning in respect to the LMC, where we have in Croatia as well as Nigeria. In case of Athens Convention, it's not possible. So if you want to be able to stay party to 2002, you have to denounce all this. We wanted to enforce this convention because it was quite modern convention and it was very favorable for passengers to change. The new basic liability was introduced. The limits were much higher. The criterion for limitation of liability was higher. And the European Union did something quite interesting and quite clever. They actually incorporated relevant provisions of the Athens and by means of, and as well as parts of the IMO resolution and guidelines, and by doing so, applicable even before the Athens Convention entered into force in 2004. At the same time, for 2 years actually later, in 2012, the European Union also acceded to the first international convention of the IMO, including the post-IMO, which was so the EU acceded to this convention and encouraged member states of the European Union to do the same, and that was the reason why many European countries actually did it. And so, as a result, we still have some member states that are not parties to the convention. However, since there is a regulation, and since the European Union Convention is actually part of the EU law and hierarchically above as international agreement, is above secondary law of every EU country, including those that are parties to the Athens Convention of 74. It's the whole area in detail, but if you have questions, we can discuss about it. It's a mixed agreement with or the competences of the EU, quite a complex story. Okay, so on this and the slide after this one, there is a comparison of the liability regimes prescribed by both PAL Convention of 74 and the PAL Convention of 2002, just to give you a short regime. So in PAL Convention 74, regarding the non-shipping incident, means all those incidents that are not shipping incidents, and shipping incidents are regulation, stranding of the ship, explosion, fire on the ship, defect of the ship, plus capsizing that was added actually in 2002. So all the other damages, meaning slipping down the stairs, poisoning the doors, or whatever happens on the ship, and it's not covered by the ship incident is covered by this regime. So in the 1974 convention, the carrier is liable, and the regime is full-based liability with the burden of proof on the claimant, and the limitation of liability public 1,666 SDRs per passenger per carriage. This amount, the same amount as we have in the, we will see later, in the LLMC convention, the first one, the LLMC of 74. So those are actually running in parallel, those amounts were the same. There was significant change in the proof still claim. However, the limitation, so limit of the liability is much higher, more than before. And another thing is changed, and this is here. This time we have per passenger on each distinct occasion, meaning that luck and had 2 or 3 such misfortunes or incidents or poison in the leg or something, will have actually not only 400,000, but actually twice as much, or 3 times this limitation. Another thing that was introduced with the complementary this compulsory insurance, will come to that later. Cannot be less than 2,000 and 3,000 SDRs per passenger on each limitation. Connected to the second slide and connected to the damages which are caused by shipping incidents. In respect of those damages that were caused by the shipping convention, presumed liability was the basis of liability of carrier, and the same amount as on the previous slide, 46,666 SDRs, again per passenger per carriage, was the criteria. And here we have so-called double tier introduced, double tier of liability. In the first tier of liability, the carrier up to 250,000 SDRs per passenger on each distinct occasion, whilst in the second tier, liable for the presumed liability for damages up to 400,000 SDR per passenger on each distinct occasion. So this second right limitation, the first limit 250,000 SDRs is actually the line of demarcation. It's not actually the limitation of liability, because he's going to be liable in the second tier as well, but not under the strict. And again, compulsory insurance is prescribed. Yeah.
Sorry to interrupt. So why they have these 2 tiers then? If it's strict liability, then
those damages that are lower than 250,000 SDR are going to be covered by the ship owner or the carrier and the insurer. And if you have amount, you have to actually, it's going to be presumed liability. So the carrier has the ability to prove that the damage was not caused by servants and agents. So he will, the first tier is going to be covered anyhow, unless the exoneration reasons cover those damages in the first tier, and those in the second tier is going to cover, but he's not going to be liable in case he manages to his side. It is the same, actually, same approach is contained in the Montreal Convention regulating the compensation for damages in the air. Yeah. Okay, is it clear? Yeah. I mentioned now, actually, by answering on your questions, but just partially. This is the carrier, and carrier is included. Carrier is also liable for acts of the performing carrier as well as for the acts of the agents and servants of the carrier on their duty. Then the second person is liable and held liable with the performing carrier, and then the rate of the amount that is recoverable under the 2002 convention from the carrier and the performing carrier and the servant 400,000 SDR. So this is the the amount that was the top of the cover. Now we're coming to the issue that I have mentioned before, and this is the limitation of liability in cases were result of war or the Terrorist Act. And as I mentioned you before, the IMO wrote the resolution and guideline, but the same thing is contained in Regulation 392 of 2009. So by means of this EU became not soft law. According to this guidelines, the carrier has rights, so he has the right to limit his to a passenger caused by any of the risks referred into paragraph 2.2, and those are actually those to move this for the following amounts. The first is 250 units of count in SDRs in respect of each passenger on each specific station, or 340 million units of count SDRs overall per ship on each specific station. And this second one is not a general limitation of liability per ship, but only for those war related or terrorist related damages. So let's see what this means in practice. In case we have a big cruiser, as one we have on the northern flight, big cruisers with 6 or more thousand passengers on board. In case we have only 12% of the amount would be covered of all the damages. So we would have around passengers because the carrier could invoke this second limitation of liability per ship, and if you divide this on 6,000 passengers, other big cruisers, you would have this as a result. And this is almost the thing that we had in 1974, but the compensation for war and terrorism act at all. So since those acts of terrorism were not usually, and before they were not compensated, it's better than nothing. Okay, apart from this, yeah.
Just a quick question. Does the crew is included in passengers?
No, they're not included in passengers. This applies. I was trying to make so the passenger is the person who is on board the ship on the basis of the contract. They don't have to pay for the contract. So even if you're on board, apply to the passenger, but it does not apply to crew. But for the crew, we could apply
618. Apply for personal injury. Crew with COVID already.
I know the difference. I was just wondering if when we are talking about the law and terrorists, maybe there are some exclusion to this topic, harm or loss due to the war or terrorism that can be included.
Yeah, but no, this is not the case with this related to the resolution. So this is the convention and the death of the dangerous passengers in the resolution of only those claims. And now something that is quite interesting and that can additionally reduce here is the Article 19 of the Law Convention and Article 5 of the Ethics Regulation. I call it Ethics Regulation. It's the Regulation 392 of 2009. But okay, here Ethics Regulation. Law. If you remember, I said that European Union incorporated provisions of the Ethics Convention, but not all of them. So the Article 19 of the to the Annex 1 of the regulation, and in this Annex 1 are almost all articles of the Law Convention, but this one is not. And in respect of this global limitation of liability, Athens regulation contains a special provision than the one contained of 2002. So what does it say? About 2002. This convention shall not modify the right to be paid provided for in international conventions relating to the limitation of liability of owners of seagoing ships. So any international convention relating to limitation of liability. What section is written that this regulation should not apply to private law under national legislation implementing the International Convention of Limitation of Liability for Maritime Claims as amended by the 31st of 1920. Okay, now let's see what means this statement. There is a list of conventions regulating limitations. The first one was that is 1924. It would be applicable because there are some provisions saying that among the states that are parties to those later conventions, these conventions don't be applied. It's 1957, which is also still important, has the 2 EU member states. Then the LMC 1974, and this one is important because more than half the world done is covered by the LMC 76. 14 EU member states are the member states of the are parties to this convention. And then there is 1996 program, one referred to in the Athens regulation, having 58 states and 62% of the world managed covered. All EU members, countries and Italy are members of the protocol, but some of them are in parallel. They have 1926 and 1992. Let's do the mathematics again. But I just wanted to draw your attention again on the significance of the EU law and the regulation. The EU is in fact part of the International Convention. So the Athens Convention is a part of the EU law, and it is hierarchically above secondary sources. The question is, which of those provisions should prevail? And this question is especially important for those states where the Athens Convention, in those, actually for those, which is the most important question, and for those where Athens Convention of 2002 is not part of their national law. The Court of Justice said that if a provision of international convention, international agreement, is directly applicable when it contains a clear, precise, and unconditional obligation, acts to adoption of any subsequent measure. So this provision is not, we cannot say that it's clear and that it's precise and unconditional, because it doesn't say actually anything. It says, yes, if there is international convention, it could be applied. So this condition is not actually explicit, meaning that it prevails, it does not prevail this international agreement. The question is the Article 5 of the Athens Regulation contrary to the Article 19 of the Chicago Convention? Because it's prescribed that they can limit their liability of 96. And the answer is that they are not contrary actually, because even the LMC 76 says it can, international law applicable in member states of the European Union is going to be the regulation, because it's directly applicable in all member countries. It's going to be applicable to liability only under the LMC 76 amended under 96. This is at least what I think. Okay, so this is what we have done. Just in case when we apply the Article 7 of LMC, let's see what is prescribed in this provision. It says, in respect of claims arising of any distinct occasion for loss of life, the limit of liability of the owner thereof shall be an amount of 175 units per count, multiplied by the number of passengers, which is significant. So it's global limitation of liability. It does not apply per passenger or carriage or per passenger on each distinct occasion. It applies to the ship as if a serious incident happens on board the ship, which is capacity again 6,000 passengers, and the ship owner or carrier actually involves the liability, limitation of liability. The amount would be this, with the amount of 0, we covered with only around 50% of the amount which is provided under the Athens Convention of 2002, which is quite significant reduction. Here, I just want to point out that this amount is actually the same amount that we have in the protocol of 1990 that I was mentioning at the beginning, which never entered into force because it was too low. So the LLNC and the Athens Convention are supposed to go in line, but it never happened. And now we have the LLNC significantly reduced, actually. I'm running out of time. Okay. So I will just say that there are amounts prescribed for cabin luggage, vehicles, and luggage other than cabin luggage, and I'm not going to go. I'm going to say that there is no, we don't have any case law on the regulation, Athens regulation. There is one on the Montreal, several on the Montreal conventions, and they can be applied with presentation. Yeah. Valuables, again, I will skip it. Something that's important. It is allowed to where you change those limits of liability, but just in favor of passenger. Those limits, vector limits, cannot be lower than those prescribed. They agree to higher limits. Those agreement has to be expressly and in writing. And loss of right to use liability is exactly the same as Martinez told you, so recognizing and acknowledge the percentage of probable results, acceptance procedure here as well, and this is actually what I want to share with you. Thank you all.